Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor at Faculty of Law, University of Delhi. Now coming to the most important aspect of today's session under capacity to contract, that is nature of minors agreement. Now remember in the last session dealing with consideration, we had clearly seen that if we refer to section 23, we refer to section 25, they are in a way stating that agreement without consideration is void, right. So the fate of an agreement which is devoid of consideration is void, yes, barring few exceptions, but in general I am saying it is void. But nowhere in the Indian Contract Act is it mentioned that what will happen or what is the fate of a minors agreement. So if there is no written law on it, yes, minor is incompetent to enter into contract. But what will happen? What will be the fate of it? Will it be void? Will it be voidable? What exactly will its final destiny be? And obviously therefore there were clashes in the decisions which were being given by High Court on that point, because some High Courts were of the opinion when they interpreted the law that such agreements will be void in nature. Some went to the extent of saying that they are voidable in nature. So there was no consistency, no uniformity in relation to this interpretation of law. Now then in that situation, crisis situation if I may say, came this judgment of 1903 which was given by Judicial Committee of Privy Council in the landmark judgment of Mohori Bibee versus Dharmodas Ghose. It was the first judgment which made it clear that a minors agreement was void ab initio. What do we mean by ab initio? Void we know. Void means that it is of no value in the eyes of law. What is ab initio? Ab initio is a Latin word, Latin phrase which means from the very beginning. So it is of no value in the eyes of the law from the very inception itself. General presumption that every man is best judge of his own interests is suspended in case of minors. This is the reason it was held that minors agreement is void ab initio, because minors category, minor is a person who is not in a position to take care of his interest, to understand that what is good for that person, what is bad, what is in his interest, what is against his interest. So that is why in Mohori Bibee it was made very clear that minors agreement was void ab initio. If I may briefly give you the facts of Mohori Bibee versus Dharmodas Ghose. Now herein Mr. Dharmodas Ghose was the minor. When he entered into this kind of agreement with a money lender, now there are two persons you need to understand. One, yes, Dharmodas Ghose. Second was Dharmodas. Third being Kedarnath. Now this Dharmodas was the money lender and Kedarnath was basically Dharmodas' attorney who was working on his behalf, who was doing the transactions on behalf of Dharmodas. He was authorized to do those transactions. So what happened? Dharmodas Ghose had mortgaged his property with Kedarnath, or basically he went to him and he offered to mortgage his property in return of certain amount of money, 20,000. In those times it was a huge amount for that property. Kedarnath, before he could execute that deed, he got an intimation which was sent by Dharmodas' mother, that see, Dharmodas Ghose was a minor, because Dharmodas Ghose had misrepresented his age to be a major. So she sent an intimation to Kedarnath that see, Dharmodas Ghose is a minor and whatever transaction you are entering into with him is at your own risk. Basically she tried to caution him, but Kedarnath thought that he was very smart. What he did, he made Dharmodas Ghose, despite getting the information from the mother, he made Dharmodas Ghose sign a declaration wherein Dharmodas Ghose declared that he was a major, or he had come of age, as we say, when he was entering into such agreement. He had put his signature, so and Kedarnath gave him an advance amount from that loan, from that money. Dharmodas Ghose was the plaintiff in this case. Dharmodas Ghose was the plaintiff in this case, and he approached the court. He approached the court on the ground that, see, I was a minor when I entered into this agreement with this gentleman, this money lender, and law says that I am not capable of entering into contract. He was represented by his guardian, his mother, natural guardian, and they went to the court. The defendant, the money lender, he had few things to say. First, that he was not aware of the fact that Dharmodas Ghose was a minor, which was disproved, right, because there was an intimation which was sent to the money lender clearly mentioning, clearly highlighting that he had given that particular intimation. He knew, the money lender was very clear, the Kedarnath who was representing the money lender, he knew about the fact that he was a minor. Secondly, then the money lender said that, okay, if the court is ready to give relief or remedy to Dharmodas Ghose, who was a minor, then the court should also, he basically prayed to the court that the court should also consider his interest and at least ask Dharmodas Ghose to repay that amount which had been advanced to him, which had been forwarded to him by the money lender, right. Now, in such a situation, the court had to take such action that basically in this case the court did not allow repayment. Court gave relief to the minor by cancelling the instrument, saying that yes, he was a minor, he cannot be asked to, no contract can be enforced against him because minor's agreement is void ab initio. Minor's consent is no consent. So, even if he signed that declaration, that is not to be considered. Fine. Now, there were certain provisions. I would first take you to those provisions, then we can come back. So, if you can see on your screen, minor was given relief as the instrument, that is the document, legal document, the mortgage deed, was set aside under the old Specific Relief Act 1877. Defendant prayed for repayment of advanced money under sections 64, 65, 68 of the Indian Contract Act, and if after nothing worked for him, nothing worked in his interest, he claimed relief under section 41. Let us see what all these sections are dealing with, and let us see why the court did not grant any relief to the defendant and granted relief to the minor by cancelling the instrument. Section 64 of the Indian Contract Act, under which the defendant prayed for relief, states or deals with a person who, having the right to do so, resigns a voidable contract, he shall have to restore to the other party any benefit received by him under the contract. Restore also means restitution, right? Restoration, restitution. That means if he is choosing to get this document declared as void or invalid in the eyes of law, it is his duty also to return the benefit which he has received. 65 says a party receiving any benefit under a contract will have to restore it if contract becomes void or is discovered to be void. Now, the court said, how can we grant any relief under 64 and 65? Because the mandatory, one of the primary requirements of both section 64 and 65 is that party with whom you have entered into that contract should be competent. So, we are saying both the parties who have entered into such a contract should be competent, but it is not the case here in Mohori Bibee, because he was a minor. Dharmodas Ghose was a minor. There were few other things which have been taken care of, which had been observed by the court, by the Judicial Committee of Privy Council in the judgment of Mohori Bibee versus Dharmodas Ghose. Let us quickly have a look at them. No estoppel against minor. Estoppel means once you have committed something, you cannot step back from it, right. So, the court in this case stated there cannot be any estoppel against a minor, because minor is not estopped from setting up the defense of infancy, policy of laws to provide protection to persons below age from contractual liability. The next thing which has been highlighted is no liability in contract or in tort arising out of contract. So, there is this famous judgment in English law, Johnson versus Pye, wherein an infant obtaining loan by falsely representing his, it was held that an infant who had obtained a loan by falsely representing his age cannot be made to repay the loan of money in form of damages for deceit, because this is a tort. This is a tort. So, basically it means that minor is not competent to enter into a contract. So, under the garb of his liability under torts, you cannot enforce an otherwise unenforceable contract against him. The third important thing, the third important, very important doctrine which was discussed in Mohori Bibee and in later cases also was doctrine of restitution. We just saw this term, we just discussed about restitution in the previous slide. Restitution basically means to come back to the original position, to restore something to another person to whom that thing belongs. It says if an infant has obtained property or goods as a result of misrepresentation of his age, he can be compelled to restore the same provided that the same is traceable in his possession. That is, he is still having the thing in his possession. That property, those goods are still in his possession and he has not done away with them. But if the same is not traceable, he cannot be made to repay as it would amount to enforcing it, right. And this doctrine of restitution was laid again in an English case, famous case of Leslie Limited versus Shell, which has been mentioned in another judgment also, we will be moving to it. So, this was the status of doctrine of restitution as it stood then, when it was laid down in this English case of Leslie versus Shell. But in India later on different connotations have been given to this doctrine of restitution, we will be proceeding to it, but starting from the beginning of the laying down of this doctrine as stated in Leslie versus Shell, it meant that a minor can be compelled to restore what he has gained, provided that property or good which he had gained from another person is traceable in his possession. And if it is money, money can't be traced, and in that situation he would not be compelled to return that thing, right, because it would amount or it would tantamount to enforcing an otherwise void agreement, right.